everyone for being here. I'm really excited to present this paper today. This is my first foray into trademarks. I usually write about patents. And this paper examines the intersection of administrative law and trademark law with a particular focus on what should be the proper standards of review that should be applied to trademark trial and appellate board determinations. And I think this is an important issue, and I think it's going to be growing within court. I do think that TTAB is garnering more and more visibility, in particular with the cancellation of the Redskins mark, received a lot of sort of national attention. And generally, I think the extent that TTAB or TTAB determinations are going to survive judicial scrutiny will depend on the standards of review that are being applied. Now, so this article starts with assuming that standard administrative law principles apply to the Trademark Office, right? We have a 1999 Supreme Court decision, Dickinson, that says the Patent and Trademark Office is an agency. Standard administrative law principles apply, right? The APA, we're going to apply this to questions of fact. Now, this technically had to do with the patent side of the Patent and Trademark Office, but the statutory similarities between what TTAB and now is PTAB are very similar. I don't think there's any really good reasons it's not going to apply on the trademark side, and most courts have come out that way. And then once you're applying standard administrative law principles to the questions of fact, it's also going to apply to the questions of law. I don't think there's a good reason. So that's the sort of baseline I'm starting with. And the article really makes, I think, two contributions. It's going to argue the Federal Circuit provides insufficient deference to TTAB determinations, both on questions of law and on questions of fact. And then I think more provocatively, especially for this crowd, I'm going to argue I think it's normatively desirable that if you do a comparative institutional analysis, in many ways I think the Trademark Office could come out ahead in sort of crafting sort of trademark doctrine to essentially effectuate the normative goals of trademark law. I'm just going to very quickly go through some background with the registration process, focusing on the formality associated with it, because this is important for what kind of deference you get with respect to administrative law. So obviously, right, trademarks registration doesn't give rise. It's use in commerce that does, but it enhances the rights you can get. If you want to register your mark, you submit an application to the Trademark Office. The initial determination about registration is made from a relatively low ranking official, and it is in many ways sort of a substantive review, right? There's sort of many of the validity doctrines of trademarks you sort of have to pass to get registered. But it's fairly informal, right? It's a series of sort of negotiations, and at least in administrative law, it looks very much like an informal adjudication. It doesn't look like, right, a civil trial or an adversary proceeding. Now, beyond this, the Trademark Office's ability to make this initial determination about registration, they're statutorily authorized also, right, to adjudicate registration denials and registration grants. So what I just mean is, you know, if you get it denied by the examining attorney, you can appeal to the Trademark Trial and Appellate Board, which is an adjudicatory body that is made up of administrative trademark judges and, at times, high-ranking PTO officials, right? And the trademark, what I call denial process, is a little bit more formal than the initial process, but still not what we would say an administrative law looks like formal adjudication. It's not governed by the Federal Rules of Civil Procedure, right? It doesn't look as much like you would a court-like proceeding. Now, if your trademark registration gets granted, right, you can go through opposition or cancellation proceedings where third parties come in and challenge, right, should that registration have been granted. And these proceedings are much more formal, right? They're governed by the Federal Rules of Civil Procedure. There's ex parte communications are banned. And if you look at generally what formal adjudication looks like in administrative law, it looks much more like this, an adversarial court-like proceeding. Even though there's not necessarily witnesses that are testimony, you can do depositions and sort of cross-examine through the paper route. Now, TTAB decisions can be what appeal two ways: straight to the Fed Circuit, no new evidence, or you can go to the district court where you can submit new evidence, and then those, once they get appealed, go to, unlike patents, they go to the regional circuits. I'm going to focus more on the Fed Circuit just because it seems like when I looked into this, still the overwhelming majority of TTAB AV decisions get appealed to the Federal Circuit than through the district court. But I do, in the paper, look at the standards of review that should be applied to the district court as well. Okay, so I'm just going to cover on the sort of questions of law, just for time, and the questions of facts get into some nitty-gritty statutory interpretation. So technically, right, if an agency is interpreting a statute, a legal interpretation of a statute that is set to, that has authority to administer, it's usually going to get one of three standards of review, right? Chevron's the highly deferential standard. An agency that has force of law authority who exercises that authority will have its reasonable legal interpretations upheld of an ambiguous statute upheld under Chevron. You don't get Chevron every single time, right? Chevron only applies, the Supreme Court made clear, if the agency has something called force of law authority and exercises that authority. How do we know when an agency has it? It's not totally that clear, but the Supreme Court has stated a grant of rulemaking authority or formal adjudication is typically a very good indicator that Congress intended it to have force of law authority. Supreme Court precedent also keeps open that sort of informal procedures can get Chevron as well, just not so clear when typically informal procedures do get Chevron. Now, if you don't get Chevron, typically you get Skidmore. We can just think of this as less deference than Chevron for this talk. And then finally, you may also get, rarely, de novo review. When do you get de novo review? If you're interpreting a statute that you don't have special responsibility to administer, the Constitution, right? All the First Amendment claims are going to be de novo review. And also, I think that's important for my paper, is something in the APA called 706-2F, which essentially says if you have a trial de novo, right, if you put in sort of new facts, then you don't necessarily have to defer. So what happens if we sort of apply this to the TTAB determinations? I'm going to focus on these inter-party proceedings, right? So should they get Chevron? Should, when they interpret ambiguous parts of the Lanham Act, should we think that during these TTAB decisions, should the Fed Circuit be giving them Chevron? Well, how do we know? We want to look at, is there any reason to think that the Trademark Office has force of law authority? So have they been given substantive rulemaking authority with this sort of core validity doctrines of trademarks? No, I don't think anyone really thinks that, but then the other question would be is, have they been granted formal adjudication, right? And here's where it's a little bit more interesting, because we've seen like inter-party proceedings have all historically, the entire time they've had it, been through these very formal proceedings. Now, it's not enough for an agency to elect to do this through a formal proceeding, right? Congress must have intended the Trademark Office to do so. Typically, Congress evinces such intent by using these magic words, hearing and on the record. So if the Lanham Act had something like the TTAB needs to have a hearing on the record when it's doing an opposition proceeding, that would be the sort of signal that Congress gave them formal adjudication. Doesn't use those words, right? I spend a lot of time looking at the legislative history of when the TTAB was created and going back and looking at all the regulations the trademark promulgated with respect to how to do oppositions and cancellation proceedings. There's not a lot of good evidence on why they sort of use these formal proceedings. And I do sort of walk through, even if it was informal adjudication that they were granted, there's some sort of guideposts in the Supreme Court decisions and in the literature about when that might be enough, and I sort of go through all of that in the paper, and I just sort of come out. It's just not completely an open and shut case. Like I would have expected the Federal Circuit at some particular time to have had a discussion about this or to have thought about this, right? When you look at Federal Circuit case law, it tells a pretty intriguing tale, right? Shortly after its inception, it just does de novo review. Why? Because the CCPA, its predecessor court, did, and that was controlling. 1984, Supreme Court came down with Chevron, arguably enhanced the sphere of where you give highly deferential review to agency actions. Fed Circuit didn't revisit the issue or think about it. Then, what's really weird, I think, on the trademark side is in 1993, you had this Fed Circuit inexplicably applying Chevron to the TTAB's legal constructions of an ambiguous provision of the Lanham Act in this Eastman Kodak Company versus Bell case. Did so, no acknowledgement, like the previous 9 years, we've been doing de novo review. No Chevron step zero sort of question, which is this idea of like, were they granted force of law authority? Are they Chevron eligible? Not that surprising. wasn't highly influential, right? The Fed Circuit sort of went back to doing de novo review and kind of ignored this one case. So if it's not clear they should get Chevron, what about Skidmore? Like, is there any reason we should be doing de novo review under administrative law? I don't think there is, right? The only thing that I think would be colorable would be this trial de novo, the 706-2F, right? But if you appeal to the Fed Circuit, you can't put new evidence in, right? So I don't think it's applicable. So at a minimum, I think they should be doing Skidmore. I go through in the paper and do what I think the deference should be with questions of fact. Also, I come out, the Fed Circuit's not getting enough deference, but I'm going to sort of skip over that for this talk right now. So the second part of the paper tries to make the argument that, okay, it would be normatively desirable if we did give the TTAB more deference, if we gave the trademark more deference than we do. And it does through this comparative institutional analysis by looking at expertise and sort of capture between the Fed Circuit and the Trademark Office. And it starts with this sort of idea, at least my reading is that, you know, the ordinary consumer mindset's really important to trademark law and policy, right? Trademarks exist only to the extent consumers perceive them as designated sources and sort of et cetera. But if you look at the literature, it seems that most people think that trademark doctrine has been evolved on this basis of judicial intuitions and sort of stereotypes rather than sort of good evidence about consumer behavior and how these sort of doctrines should evolve. And so I think there's a role, right, for expertise on like consumer psychology or sort of other behaviors that perhaps have some more consumer focus. Now, obviously, the Trademark Office does not look like the typical agency that has that expertise right now. So I'm not saying as the Trademark Office is right now, this was fantastic. But I think it has the potential at least to be transformed into an institution that could. You know, if you look at the FTC or sort of other agencies, they have a policy group with some of this particular expertise. And the Trademark Office does hold a number of sort of workshops or whatever. They have many more ways of getting information in, typically, than we think of courts. This is sort of the standard administrative law reason why we think agencies could have better expertise, right? Now, I still obviously think there's got to be a lot of changes to the Trademark Office to sort of turn it into this particular type of institution. What about sort of capture? I come through this from the patent side, and at least my reading is it doesn't seem like there's many structural things set up on the trademark side to bias it towards granting registrations, right? When I look on the patent side, there's lots of features. How the agency's funded gets over 60% of its budget through fees it only collects when it grants patents, right? On the trademark side, the fees are set much more to cover costs. It's only something like 11% that they get from registering trademarks. But again, I think that in comparison to the patent side, the Trademark Office has been sort of understudied with respect to what the particular incentives are within it. So I don't want to overstate that. But keep in mind, I think anything is a comparative analysis, right? And it's not as if the Fed Circuit has been immune from charges of being particularly pro-IP, although it's been more on the patent than the trademark side. And then finally, it is not lost on me that the Trademark Office just makes registration determinations, right? They don't make validity determinations, right? So the paper does have at the very end a way that if we're going to give more deference to TTAB determinations, especially with some of these core validity standards that they use during registration determinations, it talks about how these could propagate out to the regional circuits and the district courts when they're determining a sort of trademark infringement determination. So it's a way that the sort of expertise could percolate out and help influence the development of the core trademark doctrines outside of just the registration context.
So I like the project a lot. Let me just give you a couple of descriptive instances that may be helpful on the first part, the descriptive part of the project. And the first is the recognition of trade dress protection, which occurred from 1958 to 63, where the originally Daphne Robert Leeds recognizes the Hagen pinch whiskey bottle as protectable as trade dress. After that decision in 58, the PTO goes back and forth about what the proper boundaries are on what can count as trade dress, and they didn't really use that word. That was a phrase that comes along later. And CCPA at the time would repeatedly reject whatever limitations the PTO would. Once they opened the gates, they tried to put limits on it, but the CCPA would repeatedly reject the limits the PTO was proposing, and so we got the steady expansion in the next 5, 6, 7 years. So it's an interesting story of that sort of administrative making law and then the CCPA taking over. The other one is the sort of allowance of a uniform color to be registered as a trademark. And the Supreme Court resolved that in Qualitex, but the background before that is the PTO had said no in the sweetener case, I think it was, and it went up to the Federal Circuit, maybe it was the fiberglass insulation case, and the Federal Circuit said yes. And so then the PTO switched to yes, and so the Supreme Court in Qualitex prior says, well, the PTO says yes, so that must be the right answer.
Interesting.
Of course, they were only saying yes because they had to.
Okay, interesting.
So, interesting story. I do worry about the TTAP. In my experience right now, they do not have much sort of good consumer understanding, a real world marketplace picture of what's going on.
Yeah. No, and I think that's a good point. And also when I'm thinking about this, like, my idea, sort of generally how agencies work with this sort of expertise, right, was there'd be some sort of policy group, then they would be promulgating the sort of guidelines that then would sort of trickle down, right, that others would follow. But I understand this idea of TTAB is very different than what they see in the marketplace with the validity or the infringement decisions. Chairman?
I think this is a very valuable analysis, and I look forward to citing it when I get back to this stuff. Because I think the administrative law, some expertise in administrative law is sort of unique on the trademark side of the PTO. One thing I'm a little cautious about is the comparative institutional analysis piece as an abstract analysis, right? Well, we think that agencies generally have this kind of expertise, we think the courts generally have that kind of expertise, we believe that these kinds of capture, here are the incentives. If you look at the actual interaction that's going on right now between, say, the PTO and the Federal Circuit and Congress, the PTO is right now lobbying Congress to take away de novo review of inter partes proceedings before district courts. HR 9 right now has a provision that would say that the exclusive avenue of appellate review of inter partes proceedings is to the Federal Circuit, which is kind of weird, both from an administrative law standpoint and from this comparative institutional analysis standpoint, if you think that these are two different bodies that have different, competing institutional advantages here. And the second piece of this is that the PTO generally is P first and T second.
Yes.
Right? And so the patent side tends to drive policy on these kinds of issues.
Yes.
Such that
that's a good point.
The prerogatives of a trademark administrative agency might not actually be exercised by a trademark administrative agency. They might be exercised by a patent administrative agency, which might view the trademark side as something that it could bargain with, depending on its own institutional interests.
Yeah, I think that's interesting. I mean, I thought a little bit about like how's the trademark and the patent side sort of interact, and there is some sort of literature out there, right, about the subject matter that's put together in a particular agency and what could happen. And I definitely understand patents is more powerful, and perhaps they are arguing to get away that sort of de novo review, right, because they lost the Hyatt case, right, or like they lost the standard of review they wanted on the patent side in the Hyatt case. So it sort of makes sense that this might be a good example of that sort of trickling over on the trademark side. Rebecca?
So I've been thinking about this. There's this move to detach the Copyright Office.
Right.
And it might be worth talking about that, because the Copyright Office would like to be on its own, where it could be, fully captured, and not subject to the librarian. And then there's this alternate view, shove it into the PTO, and the PTO is trying very hard to get that authority, which is kind of interesting. Yeah, I find it very interesting. And you might look at the initiatives they did with the best practices in intermediary in DMCA takedowns. Why is the PTO interested in DMCA takedowns? Because they want copyright. Right? But also that affects the capture analysis a lot.
Yeah, no, that's true. That's true. I think that's definitely an area. I mean, I've been looking. I just haven't seen a lot in the sort of trademark literature about it, but it's interesting. I think I need to dig in more.
This stuff. The law stuff.
Well, and the other thing, so I don't know if there's a recording of this, but the quality review where they they looked at how many people were actually using the specimens that they
Yes,
reviewed
yeah,
them.
yeah.
So there was a round table
Yeah.
where the stakeholders came, and it was all people who register a lot of marks. And it was a very interesting discussion because immediately off the table, what everyone agreed was requiring actual more proof of use.
Proof of use.
Yeah, I mean, that'd be crazy.
Yeah.
Right, and I think that is an important
Aspect to it, yeah. Yes?
So, I mean, I have sort of a visceral reaction to the idea of giving the TTAB more preclusive authority than it has now, or more deference. The Federal Circuit, it seems to me, regardless of what the APA says, at least has perspective that I think is accrued through adjudicating cases that sometimes involve the abuse of intellectual property. Right, and so we see things in the Federal Circuit, like in this recent case where they said, well, we know there's no formal trademark prosecution history estoppel, but it colors the proceedings, right? Whereas the TTAB just ignores it. It says flat out, there's no such thing as trademark prosecution estoppel. They're not seeing the fallout of their decisions,
Right.
nor are they, I think, as acutely aware as the Patent Office of the potential ramifications of their decisions, in part because they figure it's not going to be incontestable for 5 years, so somebody can challenge it if they want to. In any event, it's only a presumption of validity, and the courts treat it as courts treat the inquiry as use-based. So, in my view, the TTAB just isn't sufficiently cautious and thorough, and I'm not sure what sort of tweaks can address that. I just want to point out one other thing that Rebecca pointed out, that the appellate courts have been more sensitive to claims of trademark parity, right? And claims of aesthetic functionality, I think. Federal Circuit included. The TTAB tends not to know what to do with these sorts of claims, and I don't know how your proposal would.
Yeah. So I think that's a good point. I mean, there's always this thing that if you're later on down the road, you get to see more of how things have unfolded and perhaps have a better perspective, right? Again, though, I think some of this is going to be addressed by how robust of the sort of policy group that you make, right? I'm not necessarily saying it's TTAB judges versus Federal Circuit judges, but more of like if you merely make sort of a robust policy group that's going to be more sensitive to this, right? And will be able to take this into account. Now, there's always concern, right, about capture, the stakeholders, right? This is the trade-off in all administrative laws, expertise versus this concern with respect to capture. I mean, I think those are both good points, but hopefully could be addressed depending on how you would structure this policy group.